Bonjour et merci d'être ici ce matin pour une conférence de presse au sujet du projet de loi C-5. I'm grateful that you're here for a press conference on Bill C-5. We're going to be joined here. This is a press conference of interested parties, and certainly not partisan. Comme chef de Parti vert du Canada, j'ai jamais vu quelque chose comme C-5. I've never seen a bill like this, and I've never seen a process to push it through so quickly. You could call it the big, beautiful bulldozer bill. I'm going to be recognizing in order. I'll turn the microphone next to my colleague, the Honourable Member for Courtenay Alberni, representing the New Democrats here, Gord Johns. Then we're going to turn to Indigenous leadership for their words of wisdom. Grand Chief Debassigé from Anishinabek Nation, and speaking on behalf of the Chief of Ontario, Regional Chief Abram Benedict, and also we'll be hearing from Senator Paul Prosper, who's also a Chief of the Mi'kmaq Nation, and then from two environmental law experts, Anna Johnston from West Coast Environmental Law, and Josh Ginsberg from Eco-Justice. So I'll go to Gord Johns and then to our Indigenous leadership. C'est un grand honneur d'être parmi un groupe comme ça, des experts, des avocats et les peuples qui sont contre ce projet de loi avec beaucoup d'inquiétude. Okay. To you, Gord.
Sure. Thanks. Well, it's an honor to be joining such an esteemed team. Thank you, Elizabeth, for organizing today. And I think just as so people know, obviously with Trump tariffs and the impact that they're having, we as New Democrats see certainly as an opportunity to build and to do more, buy more here at home to support workers and Indigenous peoples. But the way they're going about it, this government, is the wrong way. Certainly, it can't be done, when they're fast-tracking legislation that puts environmental, labor, and health legislation at risk and regulations. This is a massive power shift. It's lacking oversight. The bill requires much more scrutiny of this magnitude. It's an infringement, obviously, on Indigenous rights. We're going to hear from some of the Grand Chief and certainly the Regional Chief today about that. But this is an infringement on the obligation of the federal government when it comes to free, prior, and informed consent, and certainly the United Nations Declaration on the Rights of Indigenous Peoples. And we're going to hear more again from my NDP colleague, Leah Gazan, who will be speaking about that more in the coming days on behalf of the NDP. But certainly, this can't come at lowering labor and environment and health regulations. This is certainly something that we're very deeply concerned about as New Democrats. We also see nation building as building more housing and schools and infrastructure and supporting, building more hospitals as well. So I think that the government needs to make sure that they ensure that this has got proper scrutiny, and I'm really grateful for the work of the environmental organizations standing today that are going to speak about the risks that are taking place here. But fast-tracking this legislation is going to cause serious harm, and it's going to not lead to fast-tracking projects. It's going to lead to more time in the courts and more protests instead of doing what their goals and their objectives are. So we're hoping they'll work with us to not fast-track this legislation. And I'm getting fast-tracked now, so I'm going to pass it over. Thank you.
Thank you for the invite. Honored to be here. I'd like to begin by saying that Indigenous people are for development. They're for, the positive development of this country. But when we're looking at a bill like C-5, there are some necessary steps that have to be undertaken, given the breadth of what we're looking at with respect to these extraordinary powers that are contained within the bill. So I am going to be putting forward an amendment to slow down the process with respect to Part 2 of Bill C-5, and hopes that more rational minds prevail in terms of consulting with Indigenous groups, from the rights holders themselves. I'm glad we have the Regional Chief here and Grand Chief, but also from environmental experts as well, because as mentioned before, if you don't do it right now, we're looking at some potential litigation in the future. So it's best to be proactive now and not to allow this bill to take place on the backs of Indigenous people. Thank you very much.
Sego, it's been alados. Yama Miigwech for the opportunity to speak this morning about the importance of this bill, or the importance of process around this bill. I am Ontario Regional Chief Abram Benedict, and we have just experienced in Ontario Bill 5 that was a very similar approach, an approach where the process is undermining democracy, undermining the rights holders of the First Nations across Canada, in this case with C-5. The government is choosing to fast-track, use their powers to fast-track this legislation is certainly something all Canadians should be concerned about. I can tell you that the rights holders across our region, across Canada, across Turtle Island, are concerned about the process being used. Never mind the fact that this legislation changes a number of fundamental legislation that's equally important to our people to protect the most important resources, that's our lands, our water, our territories. Undermines the jurisdiction of the many communities, all of the communities across Canada. I do want to echo the Senator's comments as well. We are not in opposition to development. We're not in opposition to projects. We're not in opposition to preserving the economy and the jurisdiction of this nation. If anybody understands sovereignty and jurisdiction, it's the First Nation rights holders across Canada. But the First Nation rights holders must be involved from the beginning. Not giving 3 weeks notice that a legislation will be coming forward and giving 2 weeks notice of what it looks like, giving 2 weeks to provide comment. And then again, seeing the process streamlined, where the rights holders in Canada don't have an opportunity to speak to the legislators, the decision makers. It's unacceptable. And I can tell you that in Ontario, through the Chiefs of Ontario and with our leadership, we'll be looking at all options, including holding demonstration rally here tomorrow in Ottawa, legal options as well. The governments want to speed up processes, they want to speed up development, but this is not how to do it. We will use the courts to slow down, to ensure that the rights holders are heard, that the government does what is right and has the First Nation rights holders at the table from the beginning. So, miigwech.
Good morning. Thank you, Ms. May, for the invitation. My name is Linda Debassigé, and I'm the Grand Council Chief for the Anishinabek Nation. The Anishinabek Nation advocates and supports 39 First Nations communities in Ontario. And I fully echo Senator Prosper and Ontario Regional Chief's comments and support their comments as well. For our Anishinabek Nation, First Nations, they have not been consulted on this bill appropriately or adequately. This bill presents serious concerns that, in our view, creates a path forward for any government to create legislation that undermines the rights and interests of our First Nations people. Further, this process, in addition to what was stated, this government and its process has not allowed our rights holders the opportunity to speak in any of the processes going forward, and thereby demonstrating to us how important the relationship with First Nations people are in this country. Not moving together will make partnerships complex and create different levels of conflict. Our rights holders need to be heard, our First Nations communities that represent the voices of their people in their sovereign lands. And you know, there really needs to be another way forward that allows for appropriate and adequate consultation and consent of our rights holders, our First Nations in this province. Miigwech.
Good morning. My name is Anna Johnston. I'm a staff lawyer at West Coast Environmental Law. Bill C-5 is an assault on science and democracy. It lets cabinet ministers approve projects without any information other than the self-interested claims of proponents. It ignores decades of experience and throws the principle of informed decision-making out the window. Allowing cabinet to decide which projects proceed before reviewing them is like jumping off a cliff and then asking for the parachute. This bill lets cabinet put people and planet at risk with no knowledge of the consequences. It would shut the public out of decisions that affect them. It allows Cabinet to withhold virtually all information about projects from the public, including the project details, scientific reviews, and the advice of responsible ministers. If a highway were designated for fast tracking just blocks from your home, the minister wouldn't have to give you any information beyond the name and a brief description of it, and you would have no say in whether, where, or how the highway was built. Sure, things like high-speed rail would be welcome investments, but shouldn't municipalities get a say on where the stops are located? Public engagement is not red tape. It makes projects better, and it helps get buy-in to key decisions. Absolutely, we need big, transformative investments in projects that benefit Canada, projects like renewable energy, rail, and an east-west electricity grid. But economic uncertainty can't be used to shut the public out of decisions that affect them or run roughshod over Indigenous rights. And science can't be sidelined in the name of getting shovels in the ground. It's not in the national interest to do an end run around the processes and safeguards that Canadians have relied on for decades. Bill C-5 is as ill-conceived as it was hastily drafted. Let's send it back to the drawing board and get it right. Thank you.
And now from Eco-Justice, Josh.
Thank you, Elizabeth, and everybody for the opportunity to be here today. Canada faces challenges without precedent in our lifetime. Economic uncertainty, growing global instability, and a climate crisis that is fueling catastrophic fires and driving the loss of iconic species like caribou and killer whale. These crises are connected, and we must confront them together, strategically. We cannot build a strong economy without a healthy environment. That's why we support the goal of building Canada's future with greater speed and purpose. But we are concerned that Part 2 of Bill C-5, the Building Canada Act, risks undermining the very principles that make strong, lasting progress possible. The bill would grant Cabinet sweeping authority to exempt projects from important environmental laws, laws that exist to prevent irreversible harm. For example, today the federal government cannot issue permits by law for activities that would jeopardize the survival and recovery of a threatened species. But under this bill, the government could be compelled to approve activities causing that kind of harm, even if science warns of catastrophic consequences. The legislation also empowers ministers to override laws passed by Parliament through what we lawyers call a Henry VIII clause, which is an extraordinary mechanism that concentrates decision-making authority in the executive and weakens democratic oversight. And while we understand the need to build, this bill does not require that, as it should, that these new powers be used only for projects that help meet Canada's climate targets or environmental commitments. That's a missed opportunity and a risk that we simply cannot afford. We believe that there is a better path, one where building faster doesn't mean compromising Indigenous rights, public participation, or the rule of law. Democracy is not a barrier to prosperity. It is the foundation of it. If we want projects to be built quickly and well, they must have legitimacy and broad public trust. So we urge the government to reconsider Bill C-5. Extraordinary powers must be matched with extraordinary transparency, accountability, and a clear focus on clean growth. We want to work with Parliament, Indigenous peoples, and the government to get this right so we can truly build Canada in a way that supports both the economy and our environment. So let's move forward, but let's do it without sacrificing the democratic and environmental safeguards that Canadians count on. Thank you. Miigwech. Merci.
Je vais ajouter quelques mots seulement. Parce qu'il y a maintenant deux choses qui sont tellement affreuses. Le projet de loi lui-même et aussi le processus qui a été annoncé le vendredi passé par Steve McKinnon, en anglais, le programming motion. Cette motion pour éliminer l'étude qui était absolument obligatoire dans notre système parlementaire pour faire une étude, pour les témoignages des experts, pour les vues des autochtones et de leadership. And I will add that part one, we've mostly focused on part two. We asked the Canadian Cancer Society had wanted to be here with us. Canadian Cancer Society is very concerned that part one also represents threats to health and environment in ways that risk an increase of cancer. This is not the sort of thing one hears ordinarily about bills in Parliament. So the bill itself, as environmental law experts you just heard say, it was ill-conceived and quickly drafted. Trampling on parliamentary democracy does nothing for unemployed workers. Bulldozing through democratic process does nothing to build our economy. C-5 and the programming motion together represent a new low, or perhaps a new height in contempt for Parliament itself. And in my years observing closely Parliament, I've never seen a time when a Prime Minister's office or a government grabs onto itself new powers that it has relinquished them later. The idea that this bill will be done and dusted by Friday must be resisted, and as an effort to make sure the Prime Minister understands, we will sit through the summer. There is no objection that I've heard from any member of Parliament or any party to the idea that we need proper study. Witnesses can come forward in the summer. What is the rush to pass bad legislation that will lead to court challenges and which well could deliver this power to this future cabinet in the hands of a different Prime Minister? I urge Prime Minister Carney and his cabinet to think it through, stop the programming motion, and let the bill be studied. Merci. Nous sommes disponibles tout le monde pour les questions.
I'll start with a question for you. I know you mentioned earlier that you've never kind of seen anything like this, but is there anything in your years kind of comparatively that you could chalk this up to?
Yes, I was pretty damn shocked when Stephen Harper in spring of 2012 brought in an omnibus bill, Bill C-38, that was 400 pages long and destroyed 70 environmental laws. And it was fast-tracked. This is worse.
So what can we learn from before?
We learned from before that, unfortunately, and this is the extraordinary thing, this is a minority parliament. So what I had hoped for, and I still hope for it, I hope springs eternal within my heart and soul, and I had really hoped that Prime Minister Carney will succeed. This country needs good leadership, we need economic sovereignty, we need to be strong, we need to be united. This isn't the way to do it. What I hope for in a minority parliament would be an effort to achieve consensus and cooperation between and among the parties. I had mistakenly thought that a Liberal Prime Minister with a minority would seek votes and support from the NDP, Greens, Bloc, parties that are generally seen as progressive. It appears to me, and it remains to be seen, that Mr. Carney's new majority coalition is liberal-conservative, delivering Pierre Poilievre's policies with a more friendly face.
Sorry, not to keep you at the podium, but have you had conversations with the Conservative, particularly the House Leader or Mr. Scheer, Mr. Poilievre, with regards to trying to pump the brakes on this bill? And
I've spoken and asked directly to members of Parliament during the debate times that we have, and they are limited. The Conservatives have expressed concerns. Certainly Shannon Stubbs, MP for Lakeland, with whom I exchanged words on the floor, expresses concerns about this bill. But whether, and this remains to be seen, is this brinksmanship and a bluff from the Liberals that they can push through a programming motion and have this bill pass third reading and sent to the Senate by Friday? There's no justification for ramming this through when I haven't heard any party say that we aren't willing to continue to sit through the summer. After all, we haven't had a session of Parliament since December, mid-December. Then we had a snap election. A whole lot of legislation died on the order paper. We need to get back to work. And we are, according to the Liberal leader in the House, and from what we hear from the Minister of Natural Resources, Mr. Hodgson, with whom I also exchanged words in Maine estimates, we're in a terrible hurry. And anyone who slows this down doesn't care about unemployed workers, which is it incites me to use not parliamentary language. Pardon.
Moi, si je me trompe, mais le projet de loi ne change pas les lois environnementales. Il dit simplement que si on inscrit un projet à l'annexe, les lois environnementales, on les fait après coup. Et dans ce contexte-là, j'aimerais savoir en quoi vraiment les processus de consultation autochtones sont affectés.
Oui, c'est sur la question pour les peuples autochtones, mais c'est clair que dans les mots de ce projet de loi, il était clair que la consultation avec les nations, c'est seulement une consultation, pas une décision. Ce n'est pas nécessaire d'avoir le consensus en avant le moment quand le cabinet va faire la décision. Ce projet est dans l'intérêt national et maintenant, c'est sur la liste des projets. Et après ça, c'est clair qu'il n'y a pas une seule loi qui reste debout contre la décision que nous avons décidé que ce projet, c'est dans l'intérêt national. Et on doit faire les décisions en faveur de ce projet. J'ai jamais vu une clause comme la clause de... C'est presque... Oh ouais. Deeming, c'est la section 6, les décisions qui doivent être rendues et les conclusions et avis qui doivent être formulés pour qu'une autorisation soit accordée à l'égard d'un projet d'intérêt national sont réputés rendus ou formulés, selon le cas, en vue de permettre la réalisation de tout ou en part du projet. So, in advance, any decision or determination is going to be made, we're going to deem that it be made in favor of permitting the project to be carried out.
I understand that.
Wait.
I've read the bill.
Oh, yeah,
but
wait.
my question is, it doesn't change the way they consult First Nations in this bill. It just says that the project is deemed to be approved already. And even right now, there's no veto granted Aboriginal consultation. So what's the difference, really?
The difference is in free, prior, and informed consent. And I suppose even the hypocrisy of the fig leaf that Indigenous consultations are meaningful now. The failure to use the words meaningful consultation, to say Indigenous nations and rights holders under Section 35. And again, even the way that's phrased is odd. Rights holders where we think the project may affect their rights. How do you know that when you haven't studied it at all? I think at this point I should cede the floor to Indigenous representatives here and also other lawyers.
Thanks for the question. I mean, fundamentally, the government has said and has put in language in there that they will consult after the fact. And what we have heard from the government, they have legislation, the UNDRIP legislation, talked about reconciliation, but to my point earlier is wrong process. The government is putting through this bill, not allowing the rights holders to have any input into it. Frankly, no Canadians abroad are able to make submissions and to be heard in testimony, which is concerning. And so for the rights holders to hear from the government that we're going to do the right thing after the fact is a negative connotation to start off that process. And so as Elizabeth has mentioned as well, is that may impact. I mean, there are many situations where First Nation rights holders say that this impacts our right, and the government says they don't. And so there's going to be an impasse there of where those rights begin and where they end.
That already happens. That's my question. I mean, already
Yes.
there are some cases where there's a project proposed and Aboriginal people will say, no, we don't agree with it, and the project will go ahead anyway.
Yeah.
So therefore, my question, what's really the difference?
Well, the difference is that the process to mitigate the checks and balances will be gone. I mean, frankly, the minister can go ahead and say that there's no impact. There is no impact to any rights holders, and can approve it off they go, and that's very problematic.
Does anyone want to add anything from the legal team to the point that was just raised?
Yeah, I might. I think the courts have been clear that consultation has to be meaningful, and consultation can't be meaningful if one of the parties has come to the table with its mind closed, right? So when you have the decision at the end of consultation, when you have the decision at the end of the information gathering and analysis phase, that conversation can be meaningful throughout. The parties might not agree on the end result, but if their minds are open in that conversation, that's engagement. But when you're entering into the conversation saying the most fundamental question to be answered here, we're not going to have that conversation, that's not meaningful.
In the bill, it says that the minister responsible for the projects can ask the minister responsible for the reviews, whatever review applies in the particular case, for which conditions can be applied. So in that context, there is some room to take into consideration what
Sure.
would have been heard.
To make a bad thing maybe marginally less bad, but if you've already made the yes-no decision, the decision about whether, and then you say to First Nations rights holders, okay, well, let's talk about how we tweak this thing around the edges, that's not meaningful. That's not nation to nation, and it's not reconciliation.
I'm just going to, I want to thank again the trust that was displayed by Indigenous leadership and a member of Parliament from a different party and from Indigenous and from environmental law organizations to accept a wide open chance to maybe get some Canadians' attention on what's happening here, knowing that this is going to be pushed through the House unless more than just 2 MPs stand up and say no, more than just 2 parties stand up and say no, and ask the Prime Minister to please reconsider. A member of his own caucus, West Vancouver Sunshine Coast, Sea to Sky Country, Patrick Weiler, has pointed out that with this bill having a lifespan of 5 years, these sweeping powers could be in the hands of a different Prime Minister. Please think twice. Let's study the bill, let's make appropriate amendments, and let's see what is in the national interest, because as Josh just said, democracy is always in the national interest. I wish everybody well at the G7 in Kananaskis today. There are many problems around the world that weigh on our minds, but they're not an excuse for trampling democracy in Canada. Thank you. Merci. Miigwech.